is an appeal in the matter of Ojaleye and Secretary of State for the Home Department.
Yes, Mr. Malek, just before we start, I hope you got the direction which was sent yesterday. The case is not going to be anonymised, but we will rely on counsel not to mention the names of the children. Unless you've thought of something else, I suggest you call them C1234. Yes.
My Lords, I appear for the Secretary of State this morning, the appellant in these proceedings. My learned friends, Ms. Jagiraja and Ms. Addis, appear for Mr. Ojaleye, the respondent. My learned friends were instructed last week, and they have provided a supplementary skeleton argument and a supplementary authorities bundle.
Yes. Seen those. Thank you.
So, my Lords, Mr. Ojaleye, as the court knows, is a foreign criminal. He is a citizen of Nigeria who had been granted limited leave to remain on the basis of his family life. While in the UK with that limited leave, he committed serious crime. During the COVID-19 pandemic, the government introduced the bounce back loan scheme to assist struggling businesses and individuals. Mr. Ojaleye played a leading role in a conspiracy to commit fraud in relation to that scheme. He was involved in the creation of false documents and making fraudulent applications. He made some 52 applications under that scheme. 22 applications were successful, generating proceeds of over £1 million. 30 applications were unsuccessful, and the total value of the fraud was around £2.5 million.
Yes.
For his offending, he was sentenced to 7 years in custody. The Secretary of State, as the court knows, wants to deport Mr. Ojaleye to Nigeria in light of his offending. Judge Baffa in the First-tier Tribunal allowed his appeal on the ground that his removal would breach his rights under Article 8 of the ECHR. Judge Baffa reached that conclusion primarily on the basis of Mr. Ojalaye's family life with his 2 children in the UK.
Yes.
Judges Ruddick and Clark at the Upper Tribunal found that there was no error of law in Judge Baffa's decision and dismissed the Secretary of State's appeal from it. And this, of course, is the Secretary of State's appeal against that decision. Lords, I shall seek to persuade you that the First-tier Tribunal's decision is wrong in law.
Yes.
First,
Just before you do that, to complete the facts, have we got a release date?
he has been released.
Yeah, so if I just give you the relevant facts in relation to this. So he was released on the 8th of May 2025 on immigration bail. He was actually first...
Why was it so early? Had he done a lot of time on remand in custody? That seems to be in a 7-year sentence, doing about 18 months.
I'll have to take instructions on that.
Okay.
So he was first incarcerated on the 7th of July 2022. He was convicted on the 24th of November 2023. He's under criminal licence supervision until the 6th of July 2029. And I'll find out exactly when the criminal sentence ended.
Thank you very much.
Sorry, I should have done that.
That means that when the Judge Baffa gave his decision on the 25th of November 2024, he was still in prison.
That's right. Yeah. I think there's a reference in the appeal decision to being in the gallery and
Well, that's what I was wondering.
suggesting that,
Yes.
yeah, and I've just confirmed that with my client in any event, so yes. There was evidence before the judge. I've seen the appellant's bundle, the respondent's bundle, to show that there were regular visits.
Yes. Now we saw, as my lord says, from the Upper Tribunal decision that he had been released. It's just I wasn't aware if we had a release date, but you've given us that now.
Can I just check one thing? If he was in prison, but he was waving at his children, or his children were waving at him from the gallery, was he allowed to leave prison to attend the court proceedings?
Yes, I mean, they brought him to the prison.
Right.
Sorry, they brought him to the tribunal.
But the only contact he'd had then at the time of the 25th of November 2024 decision with his children was the prison visits that the children would have had and the waving to him from the gallery.
That's right. But obviously, if C1 was born on the 6th of March 2013, C2 was born on the 25th of February 2015, then
We
it
know
was
that, actually. Yes,
until
I was
the-
concerned with the date of the tribunal decision, and at the time of that decision, what was the state of contact, and we know now. Thank you.
Thank you very much.
Thank you.
Yes, yes. Sorry to interrupt, Mr. Malik.
Lord, so I shall seek to persuade you that Judge Buffer's decision is wrong in law. First, the judge erred in his approach to Section 117C6 of the 2002 Act. Second, the judge erred in his approach to the nature and seriousness of Mr. Ojalaye's offending. And third, the judge erred in his approach to the welfare of the children and arrived at a conclusion that is either inadequately reasoned or is perverse. And in those circumstances, my case is that the Upper Tribunal should have set aside Judge Buffer's decision as being wrong in law.
Yes.
So subject to any observations, what I propose to do this morning is to address you first on law. I will take you to the relevant statutory provisions and three key authorities on the subject. I will then address you on the facts of the case and will take you to the decisions made below and make submissions on the three grounds of appeal.
Very good.
So law, my lord, in the authorities bundle, behind tab 1, my lords will find part 5A of the 2002 Act. My lords will see that section 117 requires a tribunal to consider certain matters. In considering the public interest question, subsection 2 says the court or tribunal must in particular have regard, and subsection 2b says in cases concerning deportation of foreign criminals to considerations listed in section 117C. Section 117C is at page 5 of the bundle. Subsection 1 says that deportation of foreign criminals is in the public interest. Subsection 2 is relevant to the grounds that I seek to pursue. The more serious the offence committed by a foreign criminal, the greater is the public interest in deportation of the criminal. So in other words, my lords, there is a direct relationship between the seriousness of the offending and the public interest. True it is that deportation of foreign criminals is in the public interest. The weight to be given to the public interest increases with the seriousness of a person's offending. There are two exceptions. Exception 1, the private life exception is in subsection 4. Lords will see that it has 3 limbs. If a person has resided in the UK for most of his life, the person is culturally and socially integrated in the UK, and there would be very significant obstacles to the person's integration into the country to which he is being deported, then exception 1 would apply. Very significant obstacles, not general obstacles, but very significant obstacles to integration into the country of return. The concept of integration is linked directly, the concept of obstacles is linked directly with integration into the country of return. Exception 2, the family life exception, is at subsection 5. And Lords will see that this applies where a person has a genuine and subsisting relationship with a qualifying partner. And a genuine or subsisting parental relationship with a qualifying child. And the effect of seized deportation on the partner or child would be unduly harsh. So it is the effect on partner and the child that is relevant, not the effect on the criminal. These exceptions apply principally to those who are sentenced to less than 4 years. If a person who is sentenced to less than 4 years is facing deportation, and one of the two exceptions apply, the public interest would not require that person's deportation. But what applies here is subsection 6. This concerns people who are sentenced to at least 4 years. The statute says that the public interest requires deportation unless there are very compelling circumstances over and above those described in exceptions 1 and 2. Over and above are the words to emphasize.
Yes.
Now, there are, as the court knows, these provisions were introduced 12 years ago. There are a number of different authorities dealing with these provisions. In my submission, the court only needs to look at 3 authorities to justly determine this.
Before we do that, although you stopped at 2, subsection 2, and said the weight of the public interest is related to the seriousness, in fact, you've got to read the whole section, haven't you? And to a certain extent, we know what the minimum weight is.
Yes.
If it's 4 years, or if it's less than 4 years, between 1 and 4 years,
yeah,
the weight is such that the public interest requires deportation unless exception 1 and 2 is satisfied.
Yes.
In the case of a foreign criminal who's been sentenced to 4 years or more, the public interest, because it's a serious crime as reflected in the sentence, requires deportation unless there are circumstances, very compelling circumstances, over and above 1. So there's not a separate exercise to be conducted without looking at 5 and 6,
Yes.
4 and 6. Yeah.
Lord is absolutely right, and nothing that I say is inconsistent with that analysis. The submission that I was seeking to enforce really is that there's a difference between a person who's sentenced to 4 years in prison for an offence and a person who has committed a crime of far more seriousness for which he has received a lengthy sentence. So in other words, there is the greater the seriousness of the offence, the greater is the public interest.
Is there an obviously once you've got to be a serious criminal because you've got a sentence of over 4 years, that's the minimum.
Yes.
Can't be, but is there any exercise after that it could increase, as it were, the value of the compelling circumstances if it's a particularly bad crime?
Absolutely. Yes.
That's it. So subsection 2 does come into it, you say?
Absolutely. Yes.
And will you be addressing us on where this comes on the spectrum, bearing in mind it's obviously a serious crime because it's over 4 years, and in fact it's a 7-year sentence.
Yes.
But on the other hand, it's not a murder or a rape or serious violence or
Yes.
Major drug dealing or anything of that nature.
Absolutely. Yes. And I will, of course, address you on that and seek to demonstrate that the judge made an error in considering the seriousness of the offending. Of course, I recognize that this is a very serious offence. But I, of course, recognize that there's a difference between an offence of this sort and the offences of the sort that, Lord, you just mentioned.
Okay.
So this is section 117C. Just for completeness, if you look at page 7, you will see section 117D. And this provides certain definitions. Lord will see that a qualifying partner is a person who is a British citizen for relevant purposes. And a qualifying child is a British citizen child for the relevant purposes. So 3 authorities.
We're concerned here with qualifying children.
Yeah. So both children are British nationals. So three authorities that I will take the court to. The first is the judgment of the Supreme Court in Hache, Iraq. That, in my respectful submission, is the most authoritative authority on Section 117C. You have that behind tab 4 of the authorities bundle. So my lords will see, of course, it's very familiar territory for my Lord Justice Lewis, given the appeals that were heard a few weeks ago. This is a case that involves 3 criminals. 2 are medium offenders sentenced to less than 4 years, and 1 is a serious offender who is sentenced to more than 4 years. Lords, if you go to page 80 of the bundle, Lords will see a heading just above paragraph 19, the unduly harsh test. So under that heading, the court considers subsection 5. There is an extensive analysis of various authorities that were apparently inconsistent with each other. The ultimate conclusion that the court reached is at paragraph 41, which is at page 85. Paragraph 41, Lord Hamblen says that the best approach is to follow the guidance that is given in MK, the MK self-direction. Unduly harsh does not simply mean uncomfortable, inconvenient, undesirable, or difficult. It is an elevated threshold, an elevated threshold. The MK direction then says that furthermore, the addition of the adverb unduly raises an already elevated standard still higher. So in other words, it is an elevated threshold. But the threshold in subsection 6 is even higher. It's higher than the elevated threshold. If you look at paragraph 42, you'll see Lord Hamblen making a point that this standard is high, but the standard set by very compelling circumstances is even higher. Paragraph 43, Lord Hamblen recognizes that this self-direction involves the use of synonyms other than the statutory language. He makes the point that the statutory language caused real difficulties for the courts and tribunals, as reflected earlier in the judgment, and therefore the MK self-direction was endorsed. If you look at the next page, page 86, you'll see a heading, the very compelling circumstances test. And under that heading, Lord Hamblen considers that test. Paragraph 47 is a quote from the judgment of the Court of Appeal in that case. You'll see that paragraph B says that in cases where the 2 exceptions do not apply, a full proportionality assessment is required. That, of course, then generated some debate.
You need to read the whole paragraph, Mr. Malik.
Yeah, absolutely. So reading those words in isolation generated controversy, case law, debate, discussion that was subject to various judgments of this court. But as my Lord Justice Lewis correctly says, if one looks at the whole paragraph, you'll see that Lord Hamblen said that in conducting the assessment, the decision maker is required by Section 1176 to proceed on the basis that the public interest requires deportation unless there are very compelling circumstances over and above the exceptions.
That is what the label full proportionality assessment means in this.
Absolutely.
It means the public interest requires deportation if it's 4 years or more, unless there are very compelling circumstances over and above, and that's what it means. And a full proportionality exercise used in the abstract
Yes,
is capable of misleading.
that is absolutely right. So paragraph 49, Lord Hamblen quotes from Hashim Ali. Now Hashim Ali is likewise a case involving a serious criminal. And I do ask my lords to take a note of the quote at paragraph 49. That is central to my ground one. Great weight should be given, should generally be given to the public interest in deportation of qualifying offenders. It can be outweighed by very compelling circumstances. In other words, by a very strong claim. Now there was a good reason why Lord Reed used the words great and very. So there is a public interest in deportation of every criminal. But there is a greater public interest in deportation of those who commit serious crimes for which they receive a sentence of at least 4 years.
Can you just remind me, Hashim Ali, although it's 2016, the facts had started a long time before.
Yes.
And from recollection, 5A, Part 5A hadn't been, so they couldn't be referring to 1176C there. They were referring to it pre-177C6.
It's precisely the immigration rules, which at that point created a similar distinction between medium offenders and similar offenders. In 2014, Parliament decided to legislate on the subject directly. Previously, it was dealt with by the immigration rules. If you then look at paragraph 50, you'll see a quote from NA Pakistan. Well, this tells us what over and above means. If you look at the text between letters C and D at page 87, if an offender could point to factors identified in descriptions of exceptions 1 and 2 of an especially compelling kind, especially is the word that I respectfully invite my lords to take note of, in support of an Article 8 claim, going well beyond, and that is the other phrase that I respectfully invite you to highlight, what would be necessary to make a bare case of the kind described in exceptions 1 and 2. That person, in principle, could meet subsection 6. So something that is especially compelling, that goes well beyond the 2 exceptions. Well beyond the 2 exceptions. Now, so when I showed you paragraph 49, I picked the words great and very strong claim. If you look at paragraph 51, you'll see that Lord Hamblen says that when considering whether there are very compelling circumstances over and above the exceptions, all relevant circumstances will be considered, weighed against the very strong public interest. Again, the point that I made at the outset, that there is a public interest in deportation of every criminal, but there is an elevated public interest in deportation of those who have committed serious crime. Page 88, you'll see a list of matters that the Strasbourg Court has said are relevant. And the very first matter that is relevant is the nature and seriousness of the offence. So you get that from the statute, you get that in my submission from the Strasbourg jurisprudence as well. The nature and seriousness of an offence committed by an applicant is a relevant matter in deciding whether there are very compelling circumstances. More serious the crime, more abhorrent the crime, the greater is the public interest in deportation of a criminal. There is then a heading, rehabilitation.
Before you get to that, a number of those factors are now incorporated into the statute themselves. Parliament has taken a decision about things like difficulties which the spouse is likely to encounter. That forms exceptions. So some are not, but some are. So it's not casting away the statute.
Yeah.
And the thing I find puzzling, and perhaps you might help, is 52. Lord Reed explained that the judgments made by national legislators can be respected. But of course, and I don't know why, Lord Hamblen didn't refer to the fact that since Hesham, That's precisely what the legislature has done. So we don't need to worry about all the circumstances in the abstract. In some situations, the circumstances have been already incorporated into the legislature, although not all of them.
My Lord is absolutely right. And of course, if one reads that paragraph in the context, Lord Hemblen wasn't saying that the task of a judge is simply to look at these listed factors and to conduct a proportionality exercise in general. The task of a judge is to decide whether there are very compelling circumstances over and above the exceptions. Now, what if a person poses no risk or no real risk of reoffending? One of the points that is made in this case, you'll see a heading rehabilitation above paragraph 53, and that point is discussed under that heading. So paragraph 55, Lord Hemblen quotes from the judgment in RA. This is, in my submission, an important passage, makes an important point, which is that the fact that a person hasn't committed any other offences is highly unlikely to have any material bearing. People are expected to comply with law and not to commit offences. If someone hasn't committed further offences, if he poses no risk of reoffending, this is what he's required. That is how he's required to conduct himself. And you'll see that approach is then endorsed. And if you go to page 90, and if you look at the text that appears just above letter B, you'll see a reference to the judgment of Lord Justice Mobic in a case called Dansu. Just for the purposes of your note, Dansu is behind tab 2 of the authorities bundle. I will not take you to that authority. It is accurately summarized here. The public interest in the deportation of criminals is not based only on the need to protect public from further offending by foreign criminal, but also on wider policy considerations, deterrence and public concern. Deterrence and public concern, two separate matters. And those two matters are two aspects of the public interest in deportation of foreign criminals. Public concern is a matter that is relevant. Now, there is then an extensive discussion as to the relevance of seriousness of the offence. Now, this part of the judgment is rarely considered. It hasn't been considered in various other authorities, but it is central to one of the grounds that I've advanced. So I do ask you respectfully to consider that part of this judgment. So paragraph 60 says that seriousness of the offence is a matter which the court is required to take into account when carrying out the proportionality assessment for the purposes of the very compelling circumstances test. That is what subsection 2 requires. That is what Strasbourg case law says, paragraph 61 and 62. Now, how is it that one assesses the seriousness of the offence? Is it by reference to the sentence imposed, or is it by reference to certain other matters? That is the subject of discussion under this heading. So paragraph 66.
Well, 64 is the starting point, really, isn't it?
Yeah.
The seriousness is reflected in the sentence. That's why Lord Justice Baker will tell us that you shouldn't impose a custodial sentence and you should try and make it as short as possible.
But there are important qualifications to that, dealt with at paragraph 66.
Yeah.
Of course, this certainly is very familiar territory for my Lord Justice Jeremy Baker. So a sentence imposed by a court may well reflect various considerations. There is a reference to sentencing guidelines. The first step is to assess culpability. The second is to harm. And and then to consider aggravating and mitigating factors, and that may increase or reduce the appropriate sentence. The aggravating features may commonly impact the sentence. Likewise, if a person is of good character, then that may reduce the sentence. But Lord Hemblen says that these considerations relate to the offender rather than the seriousness of the offense. If there is a guilty plea, he then says, then that reduces the sentence dramatically if there is an early guilty plea by 1/3, and that can have a significant impact on the sentence, but it has nothing to do with the seriousness of the offense. A good example is given to illustrate the point at paragraph 68. Take example of two offenders jointly committed robbery. One person receives a sentence of 9 years after trial. The other person pleads guilty and receives a sentence of 6 years. So in that case, length of the sentence is not the appropriate guide to assess the seriousness of the offending.
They must be equally culpable.
Precisely, exactly. So personal mitigation, guilty plea, good character, these are matters that are relevant to the offender. These are not matters that are relevant to the seriousness of the offending. And therefore, that is the qualification that Lord Hemblen says is to approaching the length of the sentence as a guide to assess the seriousness of the offending.
So if you know from the sentencing remarks what, in the case of a guilty plea, what the sentence would have been but for the guilty plea, then you can assess seriousness by reference to what the sentence would have been.
Exactly. So paragraph 67, Lord Justice Hemblen makes the point here.
I remember that. I must say I find that very difficult because Parliament has actually decided that the keystone is the sentence. Well, I suppose you can still say it's the seriousness of the offence as opposed to the sentence. And as a minimum, the sentence of a particular level triggers certain consequences. But I suppose you're saying that you can never go below that minimum. But even if it's 4 years, don't forget he might have pleaded guilty and it might have been 6 years.
Yes. This is what Lord Hemblen is saying. Paragraph 67. The point about sentencing remarks. Well, the tribunal may have no information about the offence other than the sentence. If there are sentencing remarks, it would be appropriate to of course, follow them. But then, in relation to the credit for guilty plea, that will be clear from the sentencing remarks. If so, then in principle, I consider that this is a matter that can and should be taken into account in assessing the seriousness of the offence.
I can't see how it would help you to downgrade it because
Upgrade.
it can only be minimum plus.
Yes.
It can't be below the minimum.
This is precisely what Lord Hemblen is saying.
Well, I suppose somebody who would have got a sentence of 5 years but pleads guilty and gets a sentence of 3.5 years is then a medium and not a serious offender, even though his offence was serious enough.
Yes.
But then he's into the subsection 5 regime, and if he's within the exceptions 1 or 2,
He gets it.
then he gets the benefit of his plea, effectively.
See that? Yeah. Lord is right. But what one gets from this analysis is that there must be an assessment of the seriousness of the offending, and how you assess depends not simply on the sentence, the length of the sentence imposed, but why that sentence is imposed. Was there any reduction for guilty plea, personal mitigation, good character, etc. And the logic behind that is set out at paragraph 68.
So how do they work in practice? Given that the public interest requires deportation, if it's a 4-year sentence, whether it was 6 years reduced to 4 years or whether it would have been 8 years, but it's got strong mitigation, the public interest requires deportation unless. So how do you in practice take account of the fact that this was an axe murderer, not a fraudster?
So there
Which
is,
bit of the equation does it fall into?
so in my submission, there is then an inverse relationship between seriousness of the offending and the application of the very compelling circumstances test. So the more,
When you say the application, in what way?
so the more serious the offence, the more difficult it would be for a criminal to demonstrate that there are very compelling circumstances over and above the two exceptions.
So if you've got an axe murderer who's killed 8 people in a Suffolk village, he may have 2 autistic children, and if it was a 4-year sentence, you might say, well, you can outweigh the very serious offending by the autistic children. If it's an axe murderer who's killed 6 children in a village, or the Dunblane murder, it can make it harder to show very compelling circumstances.
Yes.
Can't make it easier, it can make it harder.
Yes.
I mean, I suppose it's not really going to arise in murder cases anyway, because the minimum term is going to be such that any children will have long since grown up by the time the man gets out.
It's a partner as well, though. It's a qualifying partner.
But who won't have been in a relationship with him for 15 to 20 years.
Yes, but of course, the position may, the example may arise in a case where a person who's committed murder is released, he then establishes a relationship, there is then a qualifying child.
On diminished responsibility, the axe murderer had diminished responsibility and he gets a manslaughter sentence of 10 years. It's still pretty awful to kill 6 people in a Suffolk village, or in any village.
So in other words, those kind of matters aside, you're saying it's not simply very compelling, it's even more very compelling circumstances got to be shown. It enhances the need or the strength of the very compelling circumstances that have got to be shown.
Yes, so this is the submission that I make. It is, in my submission, a submission that is based primarily on the statute that requires consideration of the seriousness of the offence.
Subsection 2, yeah.
Subsection 2. It is entirely consistent with Strasbourg jurisprudence, which requires consideration of nature and seriousness of the offending, and it is supported by domestic authority that makes it absolutely plain that there can be, that there should be an upward adjustment of the public interest in more serious cases.
So it's always going to be hard because you've got to show very compelling circumstances over and above exceptions 1 and 2 for a 4-year or more sentence. But the more serious the offending, the harder, more compelling.
How does one describe that? The even more very compelling circumstances?
So very compelling circumstances is the test. Very compelling circumstances over and above the exceptions. So there must be very compelling circumstances to surmount.
That's for someone who's just got 4 years or more, isn't it? What happens if it's sort of 6 years and it's a terribly serious offence? How do you describe that then?
So the test is very compelling circumstances over and above the exceptions. The question for the decision maker is whether there are very compelling circumstances over and above the exceptions that surmount the public interest. That is the ultimate question. So what the decision maker is doing is conducting a balancing exercise between the very compelling circumstances, between the facts in that point against deportation and the public interest. And greater the public interest, harder would it be to surmount that obstacle.
So it enhances the value of the public interest.
Yes.
So if you break it down, you've got very compelling circumstances. The circumstances are the things that exist, the facts that exist over and above exceptions 1 and 2. So that's the circumstances, the facts. They have to be very compelling. And to know whether something is compelling or very compelling, you have to compare them with what you're comparing them with. So if it's a very, very serious drugs dealer, even if it's very harsh on his children, may not be very compelling because of the need to protect society from terrible drug dealing.
Absolutely.
That's how you do it.
This is what it comes down to.
Okay.
And looking at Lord Hamlin's example of the jointly committed robbery in paragraph 68, Crown Court judges don't always set out their sentencing remarks in an arithmetical way, but sometimes they do. So if you could tell from the sentencing remarks that the man who got a 6-year sentence, in fact, the judge started at 10 years, knocked a year off because of some personal mitigation unrelated to the seriousness of the offence, and then applied the 1/3 discount for guilty plea, you treat him as a 10-year
Yes,
seriousness person.
absolutely.
I mean, you might not be able to work all that out from the sentence remarks, but if it's clear enough, then
Absolutely.
that's what you should do.
This is exactly what Lord Hamlin is saying.
Okay, thank you.
Just one final paragraph, and that is paragraph 70, which is at page 92. And there is a quote at that paragraph from a Strasbourg authority. The court has tended to consider the seriousness of the crime in the context of the balancing exercise, not merely by reference to the length of the sentence imposed. So even if one keeps the statute out of the context completely, this is what the Strasbourg court required to, but rather by reference to the nature and circumstances of the particular criminal, the offences committed by the applicant in question, and their impact on society as a whole. So there could be cases, and this is one of those cases, where there is a greater impact on the society, and there would be cases where comparatively there isn't an impact on the society as a whole. But that is essentially the task of the fact finder, the decision maker.
Well, how does that work? How do you weigh, on the one hand, a case like the present case, which is an offence against taxpayers in a way, so every taxpayer in the country has been affected by the appellant's criminality, but it's probably cost every taxpayer, I don't know, £1 or a few pence once you spread it across the millions of taxpayers that there are. How do you weigh that against a sexual offence against a woman or a child, which has a huge impact, ruin somebody's life, maybe affects their immediate family and people with whom they have relationships, but doesn't otherwise have an immediate effect? I mean, how do you weigh those two against each other? It seems a very difficult exercise to me.
Yeah.
Which of those would be the more serious for the purpose of this exercise?
So that, in my submission, that really is a matter to which the principle of deference applies. The Secretary of State makes the primary assessment as to the impact of the offending. The Secretary of State has the necessary qualifications, expertise to make that assessment. So what happens is that when a deportation order is made, there would usually be an assessment of the seriousness of the offence. The Secretary of State in one case may say that, well, the nature of the offence is quite serious, it had a greater impact on the society, and if the Secretary of State says so, in my submission, the tribunals must proceed on that basis, unless there is a good reason not to agree with the Secretary of State. But what matters there, in my submission, is the Secretary of State's assessment.
Before you get to paragraph 70, all the other matters are really an assessment of the sentence itself, isn't it? In other words, don't just take the figure of, say, 5 years. Do remember things that there may be personal mitigation, there may be pleas of guilty, which all are nothing to do with the seriousness of the offence. So that's all within the framework of the sentence itself, isn't it?
Yes.
And that's for the trial or sentencing judge.
Yes.
You're saying this is what, beyond that?
This is, yes, that is the submission that I'm making. Yes, it is beyond that. You start with a sentence, as Lord Justice Lewis has just observed. So you start with a sentence. There is a minimum public interest deportation of a serious criminal is in the public interest unless a person falls within subsection 6. So you start on a premise that there is a public interest in a person's deportation, but you then make an upward adjustments depending on the facts of the case, what the Secretary of State has said, what the sentencing judge has said.
I mean, if you follow the statute, in most cases, this is not actually going to be a difficulty, because when you get to this stage, you've got somebody who's 4 years plus. He doesn't have the benefit of the exceptions, but if he's relying on the exceptions as an example of the problem, it's not going to be enough for him to show that he's got a qualifying child. It's not even going to be enough to show that removing him to his country of origin will be unduly harsh. You only get to this situation where you've identified circumstances over and above things referred to in 1 or 2. And sadly, in most family cases, that's not going to be possible.
Yes.
It's only when you get cases like the present where it said that children have particular needs because of the medical diagnoses that you're into the question of how do you then assess very special circumstances when there may be things which are above factors 1 and 2. That's why it's important to go through the exercise to be much less problematic in most instances if you do go through the statute.
So this, my lords, is Hache Iraq. Hache Iraq has since been considered on various occasions. The two authorities that in my submission that the court needs to look at to decide this appeal. The first of those two authorities is behind tab 5, judgment of this court in Kapinyakat. So that case concerns a serious offender, a person who is sentenced to 6 years in custody for financial crimes, and he seeks to resist his deportation on Article 8 grounds. If you go to page 127, you'll see paragraph 37, where there is a reference to Yalchin, the judgment of this court in Yalchin and NA Pakistan, and then there is a quote from Yalchin. So I respectfully invite you to consider that quote, in particular what paragraph 57 of that quote says towards the end. So over and above means something more. There must be something more. And when it comes to undue harshness, which is this case, so undue harshness is an elevated threshold, and Lord Justice Underhill uses the phrase unduly harsh. So paragraph 37 is the quote, and if you look at the quote, paragraph 57 of the quote, is middle of that quote, Judge. My Lord, I refer to those considerations of whichever kind as something more. Something more.
Simply to say whether there are circumstances over and above the fact that it's unduly harsh, rather than saying unduly harsh. That seems almost absurd, but facts over and above it being unduly harsh is what he's getting at, I think.
Yes, the submission that I make is that we know that unduly harsh is an elevated standard. Undue is an elevated standard. Harsh is an elevated standard, raised further by the addition of word unduly. So it's an elevated standard. But when it comes to very compelling circumstances, it's unduly harsh, elevated standards in other way. So the point that I'm seeking to emphasize here is that it's quite a demanding threshold. Yeah. Quite demanding. And the decision makers must recognize the difference. Now, if you then look at paragraphs 41 and 42, the reference to full proportionality assessment in HARA means section 117C6.
Yeah.
And paragraph 42, over and above, there is a purpose why those words are used, and then a hypothetical example is given. So a child who is a person who is 18 years old, who is no longer a child, and therefore the exception would not apply. So that is the sort of case where the exception can apply in principle. The final authority that I'll take you to is in the supplementary authorities bundle, page 1, the judgment of my Lord Justice Lewis in the case of Lewis.
No relation, I don't think.
This concerns a serious offender sentenced to 5 years and 4 months in custody. And may I ask my lords to look at paragraph 18 in particular, which is at page 6. A person who is sentenced to 4 years or more cannot benefit from exceptions 1 and 2. Even if the exception applies, the public interest will still require deportation of a serious offender, even if he would have met the requirements of exceptions had it applied. The public interest would still require deportation, for example, even if the serious offender has a genuine and subsisting relationship with a qualifying partner or child, and it would be unduly harsh on the partner or child to deport foreign criminal. Unduly harsh is not the test. It is where you start. You then consider whether there is something over and above that. Paragraph 20, my lord, makes the point by reference to Kepenyana that the tribunals should not bypass these requirements, and there is a reason why the words over and above are used. It was often said prior to this judgment that the assessment of whether there are very compelling circumstances is an assessment of fact. It is a fact-finding exercise, and the court should not interfere with the assessment unless the decision is irrational or perverse. This is what the Upper Tribunal in that case had done. The Upper Tribunal in that case said that the assessment under section 117C6 is an assessment of facts, and the Upper Tribunal could not interfere with that. This court disagreed. If you look at paragraph 69.
Good to remember 67 en route, actually.
So 67, the appeal to the Upper Tribunal is available only on a point of law. There is no appeal on facts, indeed. But the question is
and we shouldn't rush to find an error of law simply because we disagree with a
exactly
finding.
Yeah. So the question of what circumstances exist will involve finding a fact. And in this case, I do not seek to challenge the findings of fact that are made by the tribunal. But the assessment of whether such circumstances as found amount to very compelling circumstances involve legal questions. The assessment must be conducted in accordance with the statutory framework, and you will see that the appeal is allowed on that ground too. So in this case, I said I make no challenge to the findings of fact. The complaint here involves the legal question as to whether those findings amount to very compelling circumstances over and above the exceptions. So, Lords, these are my submissions on law, and I'll now move on to the facts. So if you have the core bundle, the first document that I will take you to is the document that starts at page 113, the sentencing remarks of His Honour Judge KC, page 113. You'll see from page 114 that there was a guilty plea. The judge says that the offence is a particularly contemptible fraud. During the pandemic, when this country was suffering a great crisis because of the COVID epidemic, and there was a good deal of panic, people were dying, and people could not make ends meet because there was no business activity and lack of income. During that period, paragraph 2 says that the last thing a decent person would do is to defraud the government in relation to the bounce back loans. Anybody who abused the trust placed in them was stealing money from everybody in the country, from every single taxpayer. And the judge says, in part, caused financial problems that the country suffers from. So it's not the judge is seeking to emphasize an ordinary fraud, if that is ever the right word to describe a fraud, but a fraud that is committed against in the context of those facts. Third paragraph, this Mr. Ojaleye saw a marvelous opportunity to take money with very little effort. He arranged, this is the last paragraph of page 114, fraudulent tax documents and returns. And he was, the judge says, a key player in the conspiracy. And you had, the judge says, the knowledge and the means to obtain fraudulent documents to support loans. There is ample evidence of your role. Thousands of WhatsApp messages. Next page, page 115, the total value of fraud is over just under £2.5 million. There are 52 applications in total, 22 were successful, generating over £1 million. 30 applications were unsuccessful. The judge then considers matters that are not relevant for the purposes of deciding the seriousness of the offending, namely personal mitigation, the difficulties, the fact that Mr. Ojaleye has two children.
But if the approach is simply to assess seriousness by reference to the length of sentence, in a way, we don't need to worry too much, do we, about the detail of the fraud? We simply go to the bottom line and see that, but for the plea, it would have been 8 years.
No,
Is that too simplistic?
That is, well, yes, that is one submission that I make. The other submission that I make is that what is relevant is public concern. The point that was made in Hajj, Iraq, by reference to the judgment of this court in Donsu. If a person commits a fraud of this nature in the context of pandemic when people were dying and contributes to the difficulties that people are facing, then there is a greater public concern if that person succeeds in resisting deportation on Article 8 grounds. In assessing...
But why isn't that reflected in the sentence? The judge obviously went to the top of the range of the sentencing guideline category because of precisely these factors.
So the judge, of course, is conducting a different exercise there. The judge cannot, the judge isn't sort of increasing. There is, for example, in sentencing guidelines, a lot of this is Jeremy Baker.
But
of
this
course,
is
was
culpable
working
in harm, and surely aren't those factors
Yes.
relevant to
on the assessment.
one or either of those?
But when the judge is conducting a sentencing exercise, the length of the sentence is where you start from. But the Secretary of State's task, in my respectful submission, the task of the tribunal, is to look at the facts, the nature of the offence, the effect that it had on others, see whether the sentence is reduced, the impact that it had on society, and then make an assessment as to where public interest lies.
I'm not sure if you're not making it too complicated. Parliament has told us where the public interest lies. If it's 4 years or more, it lies in deportation. You've got to deport unless. Here, the starting point under the guidelines would have been 7 years, according to the judge.
Yes.
But he said, no, this offending is so serious, I'm going to put it at the top end of the range, which would be 8 years, but then there were factors to do with the guilty plea and so on that brought it down to 7. And in a sense, it doesn't really matter if it's 7 or 8 years. He got a long sentence because this was serious. And the question really for the tribunal is, given that sentence, are there factors over and above the impact on the 2 children, which would make it generally harsh to return him, which amount to very compelling circumstances? I'm not sure we need to go through all of this if we're a tribunal.
I take the point. Well, the submission, Lord, that I'm seeking to make is that a person who is sentenced to, say, 7 years after trial for an offence that is committed not against this particular context, but an offence which is less abhorrent, then that person and a person like Mr. Ojaleye is not to be treated in the same way when it comes to the assessment under subsection 6.
So why not if he steals £1 million from, I don't know, Barclays Bank? So all the customers in Barclays are having to pay higher banking fees because £1 million has gone missing. And the judge says this is very serious. He shouldn't be stealing from the bank and customers are suffering. I'm going to put it right at the top of the range, reduce it from 8 to 7 because of the guilty plea.
Yeah.
The seriousness has been assessed.
Which is of course quite serious. In my submission, a case like this would be of greater seriousness, where the offence is not simply against a bank, but against the background of where people are lying.
But the sentencing judge makes precisely these points, and that's why he goes to the top of the range. He says an obviously appalling abuse of a system set up to assist in a time of panic and desperate need, a matter of concern that people abuse the system. Those are precisely the same points you're making as being of weight to the Secretary of State. But it seems to be quite a lot of double counting going on if you say not only did the judge whack it up to the top of the range, but the Secretary of State can somehow treat it as even worse because of precisely the same factors.
So the judge,
It's 8 years is serious enough in itself.
Lord is absolutely right. Not suggesting, of course, the judge took those matters into account, but there is then a downward adjustment by the judge for 3 factors.
But that you can take into account, presumably, in the sense of things like plea, good character and stuff, because they're not to do with the offence. I understand that point personally. But...
So this is the point that you were making earlier. We have to treat this as effectively a sentence of 8 years worth of seriousness, because that's what it would have been, but for the plea of the mitigation.
Well, 2 points, of course. The first is that point that there was reduction for guilty plea, Ali, and good character, etc. And second, what the judge said about the particularly abhorrent nature of this offence.
Which is why he put it into 8 years. And the real question is, whether you call it 7 or 8 years, this is a serious fraud which requires somebody who's not a national and should be in this country complying with the law, we shouldn't have to put up with people, says the Secretary of State in Parliament, with people who do that. And then the pause is, but are there factors over and above an unduly harsh impact on the children, which means that we've got to pull back from that? I'm not convinced yet that you're doing anything required and already inherent in the Section 117C exercise.
May I then perhaps
Isn't your real complaint here that you'll no doubt come on to it, that the judge, you say, the First-tier Tribunal may have, in his eyes, lowered the assessment of culpability?
yes, so did not
That's a different point,
Different,
isn't it?
yeah.
did not appreciate the level of Mr. Ojalaye's involvement. That is the real point, yes.
Well, if that's the real point. Now, do you need to press the point that the Secretary of State is entitled somehow to add their view of the seriousness of the offence beyond the sentence and what the sentencing remarks have disclosed?
Well, the reason why I make that point, my lord, is that because that is the point that the Secretary of State made in response to what Mr. Ojaleye said in his submissions to the Secretary of State. But my lord, I'm entirely content to proceed on the basis that that really is the real point.
Yes.
And if I'm wrong on that, then I'm wrong. The other point wouldn't take me anywhere. So I'm content to essentially proceed on.
Right. Well, we've looked at the sentence remarks. Where do you want to go now?
Now, then, the Secretary of State's deportation decision, which you have at page 87. Sorry, the actual reasons start at page 91. And of course, this is an extensive discussion, but I will simply take you to the parts that are directly relevant to my grounds. If you go to page 26, paragraph 26, page 99, you'll see something that in my submission is truly remarkable. So Mr. Ojaleye says to the Secretary of State that when it comes to my offending, I was simply helping a friend. I wasn't aware of what I was being asked to do. Now that we know for sure from the sentencing remarks is simply false. There are thousands of messages. He is playing a key role, the leading role, the judge says. Key player in the conspiracy. He wasn't simply helping a friend. Now I say this is relevant because this is the point that he repeated before the judge. And the Secretary of State says, no, that isn't accepted. And then 27, the Secretary of State picks what the judge said about the particular abhorrent nature of this crime. The offence is beneath contempt. The offences of this nature cause a drain on public resources. And it's quite a serious offence. So this is where the Secretary of State is setting out her assessment of the abhorrent nature of this crime consistently with what the judge had said.
Well, that's the point, isn't it? It was consistent with what the judge says. So she's not going beyond what the judge says. She's just putting, as it is seen, right. I'm saying I disagree because it's clearly not what you signed up to or the evidence showed in the criminal trial.
You may in due course hear another appeal where the Secretary of State has seeks to go beyond what the sentencing judge has said, but perhaps that is for a different day. So I need not to say anything more than what you've just summarized, that the Secretary of State, agreeing with the judge, makes the point categorically about the abhorrent nature of the crime.
I think the abhorrent is your words.
That is my words, indeed, yes.
Beneath contempt.
Beneath contempt, yes. One of various phrases that the judge used.
So what she says, you can't get out of it, this is serious, we're in the first half of the equation, public interest requires deportation, and you can't dodge it. But the clear question is, What about the other side
The
of
other
the
side,
equation?
indeed. So if you go to page 101, paragraph 41, C1 and C2, child 1 and child 2. So these are relevant children. And the Secretary of State accepts that they are British citizen, paragraph 43. And
Sorry, these are C3 and C4 actually, aren't they? Because C1 and C2 is dealt with at, on page 100, paragraph 33 and
They're the
following.
two youngest, aren't they?
Yeah.
indeed, and it's just that the Upper Tribunal referred to them as C1 and C2.
Oh, did they? Oh,
There's two older and two younger, aren't
all
there?
right. Okay, well, the two,
Two younger.
there is an acceptance
Yeah.
of a genuine and subsisting relationship with all four children.
All four children. And an acceptance that the younger children suffer from autism, paragraph 43. Now, the Secretary of State
But I
then,
think it's also worth seeing that what the Secretary of State means when she accepts a genuine and subsisting relationship
absolutely,
is explained at paragraph 33, which is more than a biological relationship, more than presence. It requires a significant and meaningful positive involvement in a child's life with a significant degree of responsibility for the child's welfare. And so that is what the Secretary of State is accepting in relation to all four children, which might be a surprising concession given that he didn't live with any of them.
Yeah.
But nevertheless, that is what the Secretary of State has accepted.
yes, indeed. And the reason for that concession is that the bar that the case law has set that there being a genuine and parental relationship is a modest bar to meet. It may be that the Secretary of State felt that there were better points to make, and she makes those points.
But hold on. You say it's a low level. It's not actually. I mean, what she says in 44 is correct, isn't it?
Yes.
There's got to be significant and meaningful positive involvement
Yes.
with a significant degree of responsibility.
Yes.
And she accepts that he's had that in the children's life before he went to prison, obviously.
So no dispute about that. But of course, that is not. It's an entirely different question of whether there are very compelling circumstances.
But yes, were the exceptions to apply, but they don't. He'll have met the first part of it,
But, yeah.
and he's relying on that by analogy for the person of 160. So he at least is in the situation of showing, well, I've got one bit of the thing that applies, namely genuine subsisting relationship with the two youngest children.
And my lord is absolutely right that this appears to be a surprising concession. But there is that concession, and if I now seek to depart from it for the first time, it wouldn't look good. So
No, quite.
And you're stuck.
But
I can see that basis.
it is. I mean, it's there, so we
Yeah.
proceed on that basis. But it is surprising
it is.
that it was not explored a bit further. I mean, it's said to be that he takes them to school. Well, he's not living with them. Where is he living? He's living with another woman, as far as we know, a third relationship. How far away does he live?
Yeah.
Is he taking all four children to school every day? Is he taking them once a week, once a fortnight? We simply don't know.
Yes.
Is he helping them with their maths and their English, which it is said? Well, how often is he around there? Is he there every evening? Is he there once a week? I mean, it's completely vague, but it's all accepted.
Yes. So the way I put the case is that it is accepted, of course, that there is a genuine and subsisting parental relationship, but all those matters are relevant to the very compelling circumstances test.
Yes, but all that means is he doesn't have the ability of satisfying the exceptions, but it's accepted in the case law that if the circumstances would meet the exceptions if they applied, then that's a good starting point, but he needs something over and above. If he didn't meet the circumstances, like the Lewis case, he didn't even have a relationship with the child, he hadn't seen him for 7 years, then he would be very unlikely to be able to say there were factors over and above because there were factors that were less. But so far, he's doing well in the sense that if he's going to rely on the existence of a genuine and stable relationship as part of his case,
Easy.
the Secretary of State accepts that.
Easy. Indeed. So paragraph 48. When he is arrested, he wasn't living with the children.
No.
He was living with a girlfriend. She met that person at work and had been in a relationship with her. Indeed, when he was arrested in 2022, that was the address that he provided.
Actually, I see from paragraph 48, we do have both the address where he was living with his latest girlfriend,
Yes.
as well as the address where the younger children lived. I won't mention the addresses,
Yeah.
but do we know how far apart from each other they are? I see one's in SE15 and one we don't have the postcode.
No, but I'm sure we'll
Well, that we
get
can
that
buy,
for you.
you'll have that because it'll be somewhere in the papers.
Yes. Yes. So I'll get back to you
Yes,
on
I mean,
that.
actually, if he lived in the next street, for example, it might be quite easy to be round the house every day. But if he's living some distance away, then that seems less plausible.
The point that Secretary of State is making is that, well, he's not in a relationship with a mother. He's in a relationship with someone else, and he lives at a different address. The Secretary of State then considers the evidence of autism and particular needs. And this is the evidence that the Secretary of State considered. Paragraph 50, the Secretary of State says that, well, the mother is the primary carer. So yes, true it is that there is a genuine and subsisting relationship, but it's not that Mr. Ojaleye is the primary carer. Well, you may recall the example that is given in Cabanyaca and by my Lord Justice Lewis in the case of Lewis, of a person who is 18 years old with Down syndrome. The mother has passed away and the father is the sole carer. Different approach applies in principle as compared to someone who is not the primary carer. So there's a difference between there being a genuine and subsisting parental relationship and someone being a primary carer.
Yes, I mean, it's the autism factor in
Yeah.
this case,
It is, of course.
which the judge regards as being something more that is needed. So the question is whether there's a proper basis for that.
Yes, so autism is indeed a relevant factor. And I do not dispute the findings that the judge made. But I will explain why the judge got it wrong when I'll show you the decision.
Yep.
But the point that the Secretary of State makes broadly is one that, well, the mother looks after the children primarily.
Well, you've got to look at everything. 49, the children of challenging behaviour, and the mother written, and she said that she struggled to look after them on a daily basis,
Yeah.
and they'd be difficult to manage without his support. The implication being that in some way he's helping to deal with the two children and their needs. And if you look at 51, it's the school that says he takes them to school each day.
Yes.
So you've got not just autism, so not just a genuine subsisting relationship, but you've got autism, and you've got the mother and the school both telling the authorities
Yes.
that it's necessary to calm them down or manage them,
Yes.
and he's taking them to school.
Yeah. So no dispute about it. But Secretary of State then makes the point, Judge Millard, at the next page, that paragraph 54, that as British citizens, the children would continue to have full support of the NHS, various forms of statutory support and assistance following his deportation. The mother may be entitled to additional financial benefits and would have support of family and friends in the UK. So he plays a role, of course, but the Secretary of State says that, well, you're not the primary carer, the role isn't indispensable. Paragraph 55, the deportation would add greater pressure on the mother. And paragraph 56, that she would continue to receive full support of the NHS and rely on extended family members. So the Secretary of State is essentially saying that, yes, you're playing a role, but if you are deported, then there would be provision of adequate support for the mother, and this isn't something that is very compelling over and above the exceptions. So this is how the Secretary of State decides that there are no
59, she does also note that he could have a relationship with from Nigeria, but it may not be as easy to do so for the two children with autism, given their personal circumstances. Although she reaches the view that they could manage a relationship, and for all those reasons, she finds that the circumstances not so compelling as to outweigh the fact that he's got a 7-year sentence for fraud.
So that is what the Secretary of State decides. The judge disagrees, and the decision of the judge is starts at page 69. May I take you straight to page 74 of the bundle? You will see a heading evidence. Under that heading, the judge summarizes the evidence. And as I said, I do not seek to impugn the evidence in this case, apart from one point to which I'll come to. Now, what is it that Mr. Ojaleye is doing for the children? If you look at paragraph 22, you'll see that he referred to the girlfriend as a friend with benefits. And the evidence was that he saw the younger children almost daily. And why is that? How is it that he supports the mother? Paragraph 23, the mother is a housing officer. The mother has support from friends. And when it was put to him that the mother would be able to provide necessary care and support, Mr. Ojaleye stated that she does receive support, and he needs to be there to provide additional support, not an indispensable support, but his evidence is that I need my presence is required to provide additional support. Paragraph 26, which is central to the second ground, the appellant maintains the position that he maintained before the Secretary of State as to his offending. When he was asked about his offending, he hesitated as to whether he accepted his guilt or whether he was seeking to appeal it, but then said that he has made mistakes and took issue with the description of his offending by the judge. So he does not accept what the judge has said, and he told this judge that the main point is that I accepted that I was allowed to be involved. When it was put to him that he wasn't accepting full responsibility, he maintained his position. He said, well, the mistake is essentially to allow others to use it. Flatly inconsistent with what the sentencing judge has found. And this played a role in the judge's assessment. You'll see from paragraph 28 that the mother says that her daily life is hard, and she's on antidepressants, and the dosage has been doubled. She's of course having a very difficult time, and no one disputes that.
Yes, but you've also got to look at 28, the impact on the children. She also described how at times she needs to go work, and that leaving the two children with persons they don't know triggers behaviour, and they don't cooperate.
Yeah.
And then she said she's got the consequences when she comes home. So that's part of the picture.
That is indeed part of
managing the two children.
Yeah, that is indeed part of the picture. You then have evidence, and of course you will read this in full in due course, but I'll simply take you to the passages that are central. Paragraph 43, the evidence is that the potential deportation will have significant emotional impact both on him and the children. No one disputes that. And it is him who seeks to bring the family together. And again, that is uncontroversial. Paragraph 44 is the evidence from the school. And 45 says that the deportation, this is a case 78, would likely to have some adverse effect on their well-being and development. Some adverse impact on well-being and development. Ultimately compromising the best interests, and again, that is uncontroversial. Deportation will have an adverse impact on the welfare of the children. The judge then refers to the sentencing remarks and various submissions. And may I just take you then straight to the judge's analysis that is the subject of the appeal. And the analysis starts at the analysis that is subject of this appeal starts at paragraph 72.
But before we do that, can I just double check? 55 says that the presenting officer on behalf of the respondent accepted that exceptions 1 and 2 are met, save for the mother. So they were accepting that both there would be very significant obstacles in his return to Nigeria, the impact on him, and they were accepting, the Home Office was accepting, that there would be an unduly harsh impact on 2 children with whom he had a qualifying, with a subsisting relationship.
Yes.
So the government accepted that.
That is an acceptance, of course, which seems surprising, but there is an acceptance. I mean, I do not seek to go beyond that concession. My submission that I've made is that, well, you don't win simply because exceptions apply because you're a serious criminal.
Yeah, but that's why you read from 57 then.
So exception, yes. So it was conceded that exceptions apply. So the court must proceed on the basis that the Secretary of State accepts that the impact of deportation on children would be unduly harsh.
But the submission by the presenting officer at 57 is that the key issue was whether the impact on the youngest children would amount to very compelling circumstances. And that's right, isn't it? That is the key issue, or it was the key issue for the judge.
So the key, yes. So the key issue is whether the impact amounts to very compelling circumstances over and above exceptions 1 and 2. So not simply whether it's quite compelling, but it's compelling
Over
in the
and above the
sense that it's
unduly
over
harsh.
and above.
Yeah.
And that is really the point here. So paragraph 72. So I take no issue with what the judge has said. The judge summarizes the law, etc. So paragraph 72, the judge says that I need to undertake a balancing approach and then decide whether there are very compelling circumstances. The judge says that I remind myself of the strong public interest in deportation, and I bear in mind the proportionality assessment. Well, a strong public interest. Now, I have made a point in skeleton argument. I do make the point that there was a reason why Lord Reed in Hashim Ali and Lord Hamblin in Hatch Iraq used the word great, very strong. Not, there is a strong public interest in deportation of every criminal, but a very strong public interest in deportation of a serious criminal. So the judge there, in my submission, fails to appreciate that distinction.
You're not making a submission which I'd anticipated. If you look at the first sentence, that seems to be flatly contrary to what the Court of Appeal decided in Campinaica. It's not a general weighing the compelling circumstances against the appellant's deportation.
That is wrong.
That's precisely what you don't do. It's whether the statutory tests, you've got to look at the factors that are over and above exceptions 1 and 2. And it's not have regard to the strong public interest, it's regard to the fact that the public interest requires the deportation of foreign criminals. So really the words strong or very strong are almost irrelevant, and Hesham Ali was pre the statutory language, but you're not making that submission, so
No, no, my lord, I do make the submission. I mean, of course, you know, the first ground is one that I've made. But I do say that the judge has failed to appreciate the task that the judge was required to do under section 117 C6. And paragraph 71 in my submission discloses an error of law. The words over and above the two exceptions are evidently missing. The task of the judge isn't to decide whether there are very compelling circumstances that render the deportation disproportionate. The task of the judge is to decide whether there are very compelling circumstances over and above the exceptions. The body of the analysis would illustrate the point that the judge got the test wrong in a fundamental way.
Well, he refers in this paragraph back to paragraph 68,
Yes.
which not only refers to very compelling circumstances over and above exceptions 1 and 2, but also does use the word very in talking about the very strong public interest in deportation. So doesn't it look as if what he says in 72 is simply, as it were, an abbreviation, so as not have to keep spelling it out every time.
So 68, my lord, he refers to what Hashim Ali had said in what H.A. Iraq said about the Strasbourg jurisprudence being relevant matters. So he refers, I mean, of course, that quotation is entirely correct, but the judge makes an error in my submission in paragraph 78. He's summarizing his task. In my submission, he's misdirecting himself.
72.
In 72, yes. So true it is that 68 is accurate, but he gets it wrong when it comes to applying what is said at paragraph 68.
the problem is he might have been misled as to what the proper meaning of that paragraph in Lord Hamlin's judgment was, because particularly now, and Lord Hamlin didn't go on to deal with it, a lot of the matters have actually been put into and given weight by Parliament. I accept that some of them don't, and he's gone down perhaps, or he seems to be saying in 72, he's going down the route of doing a general assessment of taking those factors and weighing them against deportation, and that isn't what the statutory test requires. It's more focused than that. It's the public interest requires, unless there's something over and above, and most of the factors will have gone into the earlier stages.
Yes. So the one problem, again, my Lord Justice Lewis knows this too well, is that paragraph in HA used the words full proportionality assessment. And there was, of course, as my Lord knows, a tendency of reading that particular sentence in isolation.
Without reading the next sentence, which is on the basis in 1776C.
The law, of course, is now clarified in Capeniaca and in Lewis. So paragraph 72, for that reason, is wrong, and that is ground one. I'll take you to one further paragraph that is relevant to ground one, but I'll take these paragraphs in sequence just to make more sense.
So 72 you say is wrong in your written grounds. It was very much tied into the missing words very.
Yes.
You're saying that actually it's really the fact that that may be part of it, but very compelling seconds over and above the two exceptions.
Indeed. So that is the first point that I made in my skeleton, paragraph 20, that the test is in section 117 C6. If there are no such compelling circumstances, public interest requires deportation. So the judge gets it wrong in my submission for both reasons. Now, ground two is
Before
direct.
we leave that, I mean, I have some sympathy, obviously, with what you say about paragraph 72, because it's the sort of things we were saying in Lewis was wrong. The problem is when you get to the end, when you get to 78,
Exactly.
on this issue, he does seem to come back, because he says the needs of the two children in the middle are such that the deportation of the appellant is more than unduly harsh. It's not just unduly harsh.
Yeah.
And that does seem to be back onto the proper test.
So of course, I need to address that head on, but I mean, may I?
Do it in your own way, but don't ignore 78.
No, absolutely. I mean, paragraph 78 is central to the judge's analysis, of course, to my appeal. But in my submission, you'll understand paragraph 78 better if you look at the earlier analysis. So I'll take you, of course, to 78, make submissions on it. So paragraph 73, this is really ground two. The judge says that the judge deals with the submission that Mr. Ojaleye is seeking to depart from the sentencing remarks, which he was, not only in his submissions to the Secretary of State, but in his evidence to the judge, that may be indicative of lack of genuine remorse and lack of accepting culpability. The judge says it does not actually make a difference to the ultimate decision that I have to make. I'm not required to make a determination as to his culpability for the purposes of my assessment. That, in my submission, is wrong. It's wrong in law. The judge was obliged to form a view as to the nature and seriousness of the offending. Mr. Ojaleye is saying that I don't accept what the sentencing judge has said. The task of the judge was to decide at the level of his culpability, to decide to form a view as to the seriousness of the offending. The seriousness and nature of the offending is relevant. You get that from the statute, Strasbourg case law, and domestic authority. So the judge's approach at 73 in my submission is directly inconsistent with section 117C2 and indeed with the case law. His conduct was directly relevant.
But did the judge not proceed on the basis that this was a very serious offending? The thing that troubles me more is I look at matters in the round to include the accepted low risk of further offending. Well, we're not dealing with a prediction of further offending. This is a public policy decision that Parliament has decided people who are not national and who then violate the law in a serious way should not expect to stay here.
So that was the reason why I took you to the parts in HA Iraq. No one disputes that there is low risk of reoffending. But that case law tells us is not relevant, is not of any material relevance.
Well, the judge does seem to think, you would say wrongly, that the appellant's rehabilitation is a significant factor in his favour, because he mentions it in 73, looking at matters in the round to include the accepted low risk of further offending. And then when he gets to 78, that's the last point he makes. The grammar's gone slightly wrong, because he says the balance tips squarely in favour of the appellant despite his serious offending and the positive rehabilitation he's undertaking. So it doesn't make sense to say it tips in his favour despite his rehabilitation, but clearly what he means is that that is a factor in his favour, which goes into his ultimate conclusion at 78, and you would say that's giving weight to an irrelevant factor. See what you showed us in Lord Hamblin.
Indeed. So what the judge, indeed. So the judge is saying that, well, it doesn't really matter how culpable he was, because there is now low risk of reoffending.
That does make me think that he's forgotten the bit of the subsection that says the public interest requires, because even if there's no risk of further reoffending, and even if he's got himself to this position he should have been, i.e. I'm not going to commit crimes whilst I'm allowed to be in this country, that doesn't remove the public interest requirement.
So paragraph 73 is wrong for that reason, for those reasons. So this is really ground two. Ground three concerns the children. So paragraph 74, I have no doubt that deportation will have a serious impact on children. No one disputes that, except of course that the deportation will have serious impact, but that is not the test. The judge says that, well, but for the difficulties of both children, I would have no hesitation in dismissing the appeal. The judge here is saying that I'm simply allowing the appeal on the basis of the family life with two children.
The way he puts it does again make you think that he realises there's got to be something more than just family life. Because for the older two children, yes, they're going to be affected, but it's not enough. But for the younger two children, it is enough. And why? Because of their particular difficulties, because of their autism. That seems, again, to suggest that he's looking at something over and above the relationship. He's looking at the very particular needs of the two children. That's the problem that I've got with that. It looks as if he goes against you.
Yes, so no, the judge is accepting that deportation will have significant impact on the children. Yes, the judge is saying that I would have no hesitation dismissing the appeal, but for the difficulties faced by children.
So the two children, the two younger children.
Two younger children, yes.
It must be in context because of their autism.
I do not dispute that.
Mm.
But is he, of course, the question for the court, but does he appreciate that it's the unduly harsh test, elevated threshold? But at the end of paragraph 74, the judge says quite properly that there is no evidence relating to the elder children. But then the judge says something that is slightly different at paragraph 75, where the judge says that I proceed on the basis of the concession or acceptance that two exceptions were met in respect of all four children. That's got to be wrong.
So wrong that it was conceded?
So what was conceded in the decision is that the appellant has a genuine and subsisting parental
But that's the
relationship.
decision letter. At the hearing, the
Presenting
Secretary of State's representative went further and conceded that the exceptions were met.
Exceptions were met, but
That includes the unduly harsh, isn't it?
absolutely, but that
So of your four elevateds, two of them are already ticked by concession.
by concessions in relation to the two younger children. The judge, I mean, it matters not, but the judge seemed to proceed on the basis that the exception was met in relation to all four children.
Yes. When that was a concession.
Concession by the presenting officer.
Yes.
That's 55. That's what
Yes.
I asked about.
Yeah, so the concession is that the exceptions are met.
The caveat was in relation to the relationship, I think.
Yes. I accept that, but you'll see an obvious tension in the final sentence of paragraph 74, and then what is said at paragraph 75 in relation to the elder children.
Is part of your point that, I mean, it's never wrong, that the opening sentence of 74, I have no doubt the deportation of the pen will have significant impact on both the younger two children. So that, I mean, that's accepted, but that's simply not enough.
That's simply not enough. Yeah.
But this 74, 75 seems to be against you for this reason. There's been a concession that were the exceptions to apply, he met them for all four children. But he says, I would have dismissed the appeal if it was only the two older children. Why? Because it's only the fact that the exceptions apply. So he knows there's got to be something more. And in respect to the two younger children, as he goes on to explain at 75, he thinks there is something more
And the
because of the autism.
And the test is met at the top of page 85, isn't it?
Mm.
Yes, I'm satisfied the test is met. And what is that test? In my submission, the test that the judge is saying is met is what he set out at paragraph 72, which is wrong. So when the judge says test is met, that means paragraph 72. But end of paragraph 75 and paragraph 76, the judge, in my submission, begins to lose, and I say this with respect, objectivity. The judge, end of paragraph 75, the judge says that, well, the circumstances are heartbreaking emotions of the two children when they ask for their father. And then, Lords, you have, of course, seen what the judge has said at paragraph 76. Well, no one would dispute that that the children would have been pleased to see their father. But this is indicative, in my submission, of the judge losing objectivity. And really what he has done in the next two paragraphs, allowed the appeal, not on the basis of objective findings, but what he found to be real and touching emotions. The judge says, well, it's not evidence. I do not have regard to it when arriving at my decision, but surely that played a role. So paragraph 77 is wrong in law for several reasons. The judge again says, I'm satisfied that the test is met. The test that the judge has cited at paragraph 72. And then the second sentence is wrong. The particular needs of the children are such that they cannot be properly met by the appellant if deported to Nigeria. Yes, the appellant would not be able to meet those needs, but the question isn't whether the appellant is unable to meet those needs. The question is whether someone else would be able to meet those needs following the appellant's deportation.
And that's what he uses next, really. He says he understands them and can manage their emotions and behaviour. There's all evidence to that effect. They've been managed whilst the appellant's been in prison. But if it carries on for an indefinite period, he says it could be very damaging to them, i.e. they've managed to cope for the period when he's in prison. But if he goes to Nigeria and he's not there...
So it could be very damaging, that I wouldn't take issue with. It could be very damaging for them. But the task of the judge was to decide what would happen in the event of Mr. Ojalaye's deportation as opposed to what could happen. Of course, anything, it could be very damaging, it could not be very damaging. There isn't, in my respective submission, a finding as to what would happen to children in the event of Mr. Ojalaye's deportation. Could be the words that I respectfully invite the court to bear in mind. Now, no analysis in my submission here of the role that Mr. Ojaleye played in providing care to these children before he went to prison. And no reasons as to why the mother, supported by special school staff, supported by additional available support that would be available in the event of deportation, cannot properly care for the children in Mr. Ojalaye's absence.
He says, I also accept the impact that the children's behaviour is having on the mother to her mental health. Well, if the mother's mental health is suffering, then she's not going to be able to care properly for the children, and she may have, as it were, held it together for a while he was in prison, but things are risking a downward path, aren't they?
So the judge isn't saying that mother is unable to provide care for the children or will be unable to provide care for the children in the event of Mr. Ojalaye's deportation. There is no medical evidence before the judge as to the mother, but of course no one would dispute that a mother with the care responsibility of these children in absence of their father will be under great stress and strain.
And he's accepted at the end that the mother made it clear that whatever may happen in respect of her relationship with the appellant, they need the presence of the father, and he accepts that. And if we're dealing with very particular circumstances over and above 1 and 2, there's a concession about the existing substantial relationship and the unduly harsh thing. And he's saying, gosh, if he goes, this mother is telling me she can't cope and she's going to collapse. And I've got to take that into account. And the risk of that happening and the children suffering is more than unduly harsh. the children with autism will have nobody basically who can manage them and look after their needs. That's what he's saying, whether one agrees with him or not. I think.
Well, he's in my submission, he's not saying it. He's not saying that, and if he's saying that, then he's wrong. My Lord, if you look at the sort of middle of that paragraph, he makes the point that Mr. Ojaleye is a glue that brings all four siblings together. And there's a finding that the children enjoy their time together, but no reasons as to why their mothers cannot facilitate their meetings. True it is that they do not currently communicate, as the judge says, but it's entirely reasonable in my submission to expect them to make some adjustments. And even if the mothers would not allow the meeting by choice, it is difficult to see how that could count as a factor mitigating the public interest in the deportation.
Whether the two sets of half siblings meet is perhaps a less significant matter than the basic care needs which the younger children have. I mean, these are we're told, very severely autistic children. They have need help with very basic needs. They exhibit what is described as very challenging behaviour. We have some sense of what that means, even though it doesn't go into detail. But these are children whose care is very, very demanding.
Absolutely. So no one disputes that. The mother is capable of providing care. She's supported by specialist school. She has support of NHS. She will continue to have support pursuant to various statutory responsibilities in the event of Mr. Ojalaye's deportation. I mean, no one, I mean, it's of course uncontroversial that, well, all children, where possible, be brought up with close relationship with both parents. And again, it's uncontroversial that it is in the best interest of these children to be with their parents. But the whole point of deportation, my lords, is that it brings an end to family units. That is the purpose of the deportation. If you commit a crime, then the public interest would require your deportation unless there are very compelling circumstances.
Well, it's a consequence rather than a purpose, but I see what you mean.
That's a consequence, indeed.
Yes. All right.
But the judge, in my submission, is not saying in this paragraph that the mother is not capable of looking after the children, or the impact of deportation would be very damaging. And the judge gets it wrong in my submission by assessing whether the appellant is able to meet needs from Nigeria. Of course, the fundamental point above all is that the judge says at the outset that I'm satisfied that the test is met for these findings. The test that he has identified is wrong. The final paragraph, of course, that I must deal with is paragraph 78. The judge says that he's allowing the appeal essentially because of the best interest of the children. Best interest is not a paramount consideration in this context. Cannot surmount the public interest. That isn't the test. So the judge cannot allow the appeal on the basis of best interest. That the task of the judge is to decide whether there are very compelling circumstances. There is a strong public interest in deportation of foreign criminals. A strong public interest. Now, why is it that the word very is used in HA, Iraq, great weight is used? Because there is a greater public interest which the judge fails to appreciate. However, and no assessment of the seriousness of no proper assessment of the seriousness of the offending. For the reasons given above, and these are all the reasons, I'm satisfied that the very compelling circumstances test is met. Again, you'll see that over and above, there's no reference to over and above again. And why is that? The needs of the children are such that deportation of the appellant is more than unduly harsh. So this is the point, my lord, that
That's the problem.
Lord Justice Lewis made. But this is, in my submission, just flatly wrong. The judge is saying deportation is more than unduly harsh. The question is whether the effect of the deportation on the children is unduly harsh, not that deportation is unduly harsh in some general sense.
But really, and it's not well written, this judgment. We've all written judgments that are not well written. And he says the needs of the two children as such. He's looking at the needs, and it's the needs of the children that make deportation more than unduly harsh.
So
he's, you could have put it differently, but he does seem to be tying it to the needs of the children and saying it's over and above, it's more than.
indeed. So needs of the children, yes. And that, the judge says, there is something more than unduly harsh. The test is whether the effect of the deportation on the children would be unduly harsh, not that the needs of children would be unduly harsh in general sense. So why is it that the effect of the deportation would be unduly harsh on children? Sure, it is that they have quite demanding needs. But the fact that the needs are really demanding and one has sympathy for the family does not mean that the effect of the deportation would be unduly harsh. The judge then says, if you
But if
read...
the needs are really demanding and they call for the parent to be present and the parent isn't there.
Mr. Ojaleye is not there, yes. But this isn't, in my submission, what the judge is saying. The judge isn't saying that, well, the needs are such that Mr. Ojaleye needs to be with the children. Absent Mr. Ojaleye, those needs would not be met. The judge is saying that, well, the needs are unduly harsh and more than unduly harsh in a general sense.
So what are you saying, that that's not enough, saying more than unduly harsh? He should have recited these amount to very compelling reasons over and above the two exceptions?
That is, of course, one point, but I'm making with respect a different point, which is that the subsection 5 says the effect of deportation on the qualifying child is unduly harsh. So it may be that a child has autism. It is unduly harsh for the child to live with autism. It is unduly harsh in a general sense that they have needs.
What you're saying, I think, really is because a child has needs, doesn't tell you whether or not those needs are going to be met, and whether the effect on the child, if something happens, is going to be more than duly harsh. They've got to assess the effect of the absence of the parent on those needs.
Exactly.
That is
the point.
It's not so much what's said. Are you saying he hasn't done an assessment as to the effect?
Well, he hasn't done the assessment. So earlier on, I have of course made submissions. That's 77. Well, it could be damaging, he said. Not that it would be. Why is it that those needs are not met by the mother, supported by the specialist school, and everyone else? That will, and the next part of the sentence is equally wrong.
Yeah. What you're really saying is he's got to find the facts that show that the effect of the parent being absent, given those needs, and he hasn't found, or you said in submit hasn't found, what the factual effect would be. Yeah.
Now, the later part of that sentence is also wrong. Will create communication barriers and difficulties that goes beyond very significant obstacles. Now, this is the first exception. The first exception is very significant obstacles to someone's integration into the country of return.
I agree with that. I think there seem to be three things there. The first bit is unduly harsh because of their needs, and that seems to be addressing how they'll be managed, their needs will be managed. The second one is referring in shorthand to a separate topic, which is how will they be able to communicate with their father? For a lot of children, it may be you can get by with telephone, internet, and so on. But these two children, it's difficult, and even the Home Office accepted that in their letter. And then there's a third thing, which I do admit is very odd, which says difficulties that go beyond very significant obstacles. That is exception one. You've conceded that there are very significant obstacles, which in itself is surprising. And you're saying, really, he hasn't said what is it over and above the things you conceded, which bring it within two, I think.
So over and above, exception one means over and above to very significant obstacles to integration into Nigeria. So what is over and above that? In my submission, there isn't. And for that reason, for those reasons, in my submission, paragraph 78 does not save the judge's decision. The concluding sentence, I have to say that balance tips squarely in favor of the appellant. Despite his serious offending and positive rehabilitation, of course, something has gone wrong with the sentence. But this reinforces the submission that I made, that judge thought that he was conducting a conventional balancing exercise rather than considering whether there are very compelling circumstances over and above the exceptions. And for these reasons, in my submission, Judge Bapa's decision is wrong and wrong. Now, these are the grounds that are essentially for the court to decide whether these grounds are made out. If the court decides that there is no error of law in the judge's decision, the appeal fails. If you decide that there is an error of law, then you will allow the appeal. It matters not what the upper tribunal has said because of the nature of the exercise that the court is
Can we just explore the consequences if you succeed on one or more of your various grounds, because they may be different, I don't know. Ground one, essentially he got the test wrong.
Yes.
If we agree with you about that, does that mean it has to go back?
Yes.
Or so it's not we can't do it for ourselves. Ground two didn't give enough weight to the seriousness of the offending. Is that the same consequence? Needs to go back and be done properly?
Yes.
And similarly on ground three?
Yes.
Yes. Okay. So you're inviting us really to allow the appeal and send it back to the FTT to start again.
Indeed, either to the First-tier Tribunal or to the Upper Tribunal. The Upper Tribunal has the same powers, expertise. One matter that, if the court is persuaded by the submissions that I've made, is to consider whether there is, as the court would know, extensive caseload at the First-tier Tribunal. So that is a matter indeed for the court. If you are persuaded that there is something in the grounds, so I invite you to set aside and remit it to the Upper Tribunal.
We haven't heard the oral evidence, of course. In some cases, OSB, this court actually remade the decision, but this is different because we haven't heard the mother, we haven't heard the school teacher, and you need to know what they were saying to put it into the statutory framework.
Yes.
All right.
So unless I can assist you any further, these are my submissions.
Thank you very much indeed, Mr. Mann.
Okay.
Yes, Mr. Garrett.
Same, can I have the lectern?
Sure.
You're aware, I'm sure, that we have been sitting for more than 55 minutes. That clock is wrong.
Thank you.
So you've got about 20 minutes, I think, before we break.
Thank you. So yes, the last point that your lordship made was not having heard oral evidence. And actually, if you take that further, the judge did hear the oral evidence, and he also had the appellant's bundle, and he had all of the witness statements. So all the points that were raised concerning residence, for example, where was the respondent living, those are all completely before the judge. And just to deal with this point of whether the respondent was living with the family. I've got the bail conditions here, and these show that following his release, he went back to live with his partner. And both the witness statements have consistently maintained, I mean, obviously there was, you know, there are side issues that are going on in relation to another woman, but I'm just going to park that. But the bottom line, in terms of the evidence that I have read within the kind of 5 days that we've had this case, are unanimous in terms of the respondent's partner being his partner. It may well
The
be.
problem is we can't deal with that because we don't have that evidence. All we can deal with is whether the judge on the evidence that he had was correct. If he was correct, then it doesn't matter, the appeal will be dismissed. If he wasn't correct, you're telling us not only is there evidence that we haven't heard because we weren't the judge below, but there's also new evidence or fresh evidence as to what happened after the first-tier tribunal.
Oh, no, I'm not talking about any new evidence. I'm just making the point that what's not before you is the evidence, the subjective evidence that was before the first-tier tribunal
So
judge.
what, there was evidence before the FTT that he, I thought at the time of the FTT, had he been released by then?
No.
No. What
so
I'm saying is, today the Secretary of State has been making various points about the facts in the case, and I simply want to make the point that this court does not have all the facts in the case because you don't have the respondent's evidence as it was
There are
before
two
the
things,
judge.
I think. Firstly, we don't have the evidence that was before the first-tier tribunal. That's one set of evidence, and we don't have that, and that's the point that I made. What you've just said, with all due respect, appears to me to be amounted to further new evidence since the tribunal
That's
decision,
true.
because he wasn't released on bail until after the first-tier
That's true.
tribunal. And we don't know anything about that. You say it, but you can't give evidence.
No.
So if we allow the appeal, and we may not, then that's a further reason, because there might be further evidence.
Yes, Judge, I recognise that. I just wanted to clear up the position in terms of bail. But just in terms of some of the earlier questions, I think I've gone through it before, that the criminal licence supervision ended on the 6th of July 2029, and he was due to be released in 2026, but he was released early on the 8th of May 2025. I want to make some general submissions. Firstly, my learned friend's submissions concerning the seriousness of the offence and the public interest and the relationship between all of that and how it feeds into very compelling. In my respectful submission, this has all been resolved very clearly in the authorities. So if, for example, I mean, it's all been set out in HA Iraq, and I think having a more structured approach to the judgment rather than being taken to certain passages there, there are certain passages here that resolve the issue very clearly. That's one point I want to make. So the law is clear in relation to issues of double counting, and you know the difference between, let's say, a 4-year sentence and an axe murderer. So that's resolved, and I'll take you to the passages there that address that clearly. The other area that is not covered by the Secretary of State is the status of children's rights and Section 55, and how all of that feeds into a criminal deportation case, and in particular, how does it feed into a 4 years plus case, and that is something that tends to get overridden or excluded in practice, and I mean in practice before a first-tier tribunal, which is where I practice, dealing with in criminal deportation cases.
I thought that was exactly what the test of unduly harsh was meant to encapsulate. You're looking at the effect on the child, and we used to have the checklist in the European case law. Now we've got the statute, and when you're assessing unduly harsh, you're looking at the effects on the children, and that will involve looking at their best interests as part of the unduly harsh.
What I mean in particular is that in HJ Iraq, in this particular case, there is a reference and engagement with the Secretary of State submissions concerning the, let's say, the uniform child. So often it's said, and I believe it has been said to some extent by the Secretary of State, that in the event of a criminal deportation, there is ordinarily going to be an adverse effect on the children. And that's a common submission that's made, and it was made formally in this particular case.
In Iraq, they were dealing with whether or not you had to have over and above the comparator approach, and the court said in the Supreme Court that was wrong. That's one thing. You don't have to do that exercise. You're looking at the effect on the children in the particular case. But your point was really Section 55 in the best interest. And the assumption has always been, as I understood it, that the very words unduly harsh involves an assessment on the impact of those children in that case. So I don't see what the problem is. We know it's not going to be in their best interest because it's unduly harsh.
What I'm trying to say is that it's very important, and I think this is what the courts have been saying, to have a non-prescriptive and fluid approach to considering the best interests of the child. And that, in fact, when looking at very compelling, regard was made to the core European cases. For example, Bultiff, where all the relevant considerations were set out there, that include the seriousness of the offence, for example.
The seriousness of the offence has now been built into the Act in the way we've discussed, because they've got these gradations of less than 1 year's imprisonment, you're not a foreign criminal. 1 to 4, you are, and it's medium, and so on. You're dealing with something different, which is the effect on the children, the interest of the children, and the best interest of the children. I'm asking just for help, really. That's what I thought. That's what I've been told in many cases. The unduly harsh test partly encompasses. Because if it's unduly harsh on the children, that's obviously not in their best interest. And that's why, if you're a medium-term offender, 1 to 4 years, if you can show unduly harsh effect, then you won't be deported. When you get to the 4 or more years, it's different. Yes, there will be an unduly harsh effect on the children, so it's not going to be in their best interest, but that's what Parliament has said. And then you're looking for something over and above the unduly harsh impact.
I think perhaps not. I think clumsily what I'm trying to say is that it is important to have regard to the effect of KO Nigeria, first of all, on the need for culpability, not to colour the welfare assessment in terms of children. That's one point. And the second point is that when looking at the children assessment, the whole question of the invariable recognition that deportation will have an adverse effect on children, almost as if that is a matter that should be excluded because it happens anyway in any event, is a factor that the courts have held is to be excluded from judicial consideration. And I'm wondering if I can just take you to the passages to make good my submissions.
Yes, do take us to what you need to take us to, certainly.
So the case of HA Iraq starts off at page 71. And at page 81, there is reference.
I haven't got a page 81 or a page 71. I've got. Oh, hang on, no, I may have. I've got a different bundle, haven't I now? Bear with me. Yeah.
It's in the main authority.
It's in the main authorities bundle. It's not the supplementary one, yeah. So I've got it now. It's my fault entirely. Page 71, yeah.
It's 81.
Oh, 81, yeah.
So at paragraph 23, the Secretary of State, the degree of hardship which would necessarily be involved for any child faced with the deportation of a parent, and that undue harshness means a degree of harshness which goes beyond that. It is this notional comparator which provides the baseline against which undue harshness is to be evaluated. So what I was trying to explain in my submissions is that later on the court goes on to disregard this approach.
Well, they said he was wrong.
Yes, yes. But the more general guidance that's given from paragraph 37 onwards at page 84 are considerations that I would ask the court to perhaps remind themselves of in the context of this case. So paragraph 37, the notional comparator is inconsistent with section 55. There requires to be a clear idea of a child's circumstances. The focus needs to be on the individual child, but the discounting of what are said to be the normal or ordinary effects of deportation. And paragraph 38, the notional comparator approach, gives rise to the risk that a tribunal will apply an exceptionality threshold, searching for particular features which take the facts of an individual child's case outside the ordinary run of cases is likely to mean looking for exceptional or rare cases.
Yes, and we don't do that, and we haven't done it since HA Iraq. And what you do is you apply the unduly harsh test as described in 41. And here it wasn't unduly harsh, it was contrary to their best interests. The question is, Parliament says that's not enough if you're a serious criminal. There's got to be something over and above that.
And what is up and above that, I would suggest, is at paragraph 51 at page 87. So when the court is looking at the very compelling circumstances test, just going back to 86, and I think this is something that your Lordship had stated right at the beginning in terms of engagement with my learned friend, that the statute has already set out how to deal with serious offences and the approach in the context of Article 8. And at paragraph 51, when considering whether there are very compelling circumstances over and above exceptions 1 and 2, all the relevant circumstances of the case will be considered and weighed against a very strong public interest in deportation. It then goes on to set out and summarise the lead European cases from B to E. And part of that includes the nature and seriousness of the offence committed by the applicant.
And 52 goes on to say, the Supreme Court has said they can do it in legislation, and this court has said in a binding decision I handed down a week ago that most but not all of the factors are in the Act, and some of them are not in the Act. So you take account of them, but the weight, for example, as to seriousness, has been attached by Parliament, with exceptions. The need to focus on the best interest of the children have been incorporated into exception 2. So I'm struggling to know what it is that... I understand why the way he's put it, Lord Hamlin, if not read in context, might be open to things being misled, but we don't know how we've got to do it. You've got to do the statutory exercise. There may be other factors, including the ones listed that haven't been incorporated, but I'm not sure where you're getting with this, actually. I'm not sure at the moment how this...
I'm getting at, when looking at very compelling in the context of children and this particular case, anything that is potentially relevant, that would ordinarily be relevant in terms of Article 8 and in terms of judicial discretion, are properly factors that are to be taken into account.
But
is my
the
submission.
judge, it's been conceded that it's unduly harsh on the child. So anyway.
So in terms of this case then, and going back to the facts of this particular case, your Lordships have looked at some of the language that Judge Baffa had used, and Judge Baffa was the same judge as the judge who considered the case in Lewis. And those two cases are almost like flip sides of the same coin. Because in Lewis, Lewis himself had committed a number of serious crimes, whereas my client was of good character before the commission of what is, of course, a very serious offence. And he was then released on early bail. Also in Lewis, he was somebody who didn't have actual family life with his son. But in this case, and this is an important consideration, the judge had seen and heard the family as a whole. And I hear what we're saying about the judge seeing and having a sense of the family life in terms of emotion. But sometimes that kind of emotion is also important when trying to determine the very difficult question of the actual fabric of family life. And so having found the evidence, the subjective evidence from the partner, which is that these are not just autistic children, but they're autistic children who are high up on the spectrum. So they're in a position where they are difficult and they have very basic difficulties in living and learning to be independent. This is a great deal of labour-intensive work by any parent. So when I drafted my skeleton argument, the supplementary skeleton argument, what I tried to do is to demonstrate all the directions that the judge gave in terms of the law. One of the things that Lord Justice Lewis pointed out in the case of Lewis is to look at the sole issue that Judge Baffa had directed himself to. And your lordship had also commented that that wasn't entirely correct because there was no reference to the need to go above exceptions 1 and 2. Whereas you'll see that in this case, Judge Baffa did actually do that, which means that his starting point in terms of his evaluation of all of the evidence and all of the law was already premised on a correct legal footing. And then when going through the rest of the determination, I can say in a nutshell that, and I've identified some of the paragraphs in the skeleton argument, where the judge clearly had no sympathy with the respondent in terms of criminality. And as has been noted by this court, he had on 3 occasions said that he would have dismissed the case if it were not for the facts of this children. And I just want to say something about the adult siblings, because the issue of the 4 siblings and the adult siblings, and I appreciate having adult siblings who you're not cohabiting with is of lesser consequence. But the significance for the autistic children, the 2 autistic children, is that there is importance for them to have a consistent relationship with family members.
So when you say adult, do you mean adult or do you just mean
Yeah,
old?
no, I do, because
You mean older rather than adult, don't you?
C3 and C4. So C4 was born on the 29th of September.
They're 15 and 18,
2010.
aren't they?
Yeah, so there's
Oh,
an 18-year-old.
18 is adult.
Yes. So their world is going to inevitably be quite narrow and excluded because of the nature of their individual conditions. And that's why the whole question of the glue and being able to manage a quite complex set of relationships with 2 partners are in the best interest of the children. So everything always turns on, ultimately, the 2 children, and in fact, all of the evidence in the case. So examining this case, we have obviously at paragraph 16 of the decision, the issue of being low risk. But again, I accept that being of low risk is of little or no consequence to what the judge has to decide, because you would expect him to be no risk. I mean, if he wasn't, then it'd be really difficult to advance the appeal.
It's more than that. Parliament isn't concerned with the FTT predicting as I said, Parliament has said if people come to this country and they're here, they're expected to be law-abiding. And if they don't, they'll be deported. And if they're serious criminals, they'll be deported unless there are very compelling circumstances over and above 1 and 2.
Well, that's-
That's what the
It's just so
Well
odd
said.
because when I do an appeal on a regular basis, I mean, why do we put these OASIS reports in the first place?
one does wonder, but I don't do the
But they are,
appeals.
but they are considered to be very important. So, I mean, that's why what a person thinks about their own criminality, all of those factors, it would just be surprising if that didn't feed into the very compelling test.
Right, would you like to find a convenient moment? Is this one?
Yes?
Yes?
Thank you.
Well, I think it's 1 o'clock or thereabouts, so we'll resume at 2.
Court rise the table.